Hello. On behalf of the Tennessee Association of Professional Mediators, commonly known by our acronym TAPM, today our mock mediation is also a Rule 31 mediation, so you will see many of the guidelines and requirements of Rule 31 employed in our mediation process today. Some things you will not see because they will have already occurred prior to the mediation session. These will include the mediator having given a written disclosure of his relationships with the lawyers and the parties, and the mediator will have entered into a written agreement concerning his fees and costs, which is also required by Rule 31. And very importantly, the mediator will have had a convening telephone conference with the lawyers and perhaps even the parties themselves, in which the case was discussed, certain protocols may have been agreed to, a time established, and very importantly, who would attend the mediation, particularly the parties with authority to resolve the dispute during the mediation session. The mediator will also have received mediation statements or position statements from the lawyers explaining their clients' respective positions about the dispute that will be mediated. Now, this particular mediation is over a commercial dispute involving retail ice cream stores, but it also has significant employment law and discrimination law issues at play. Now, our mock mediation begins with the mediator's opening statement, or as Rule 31 calls it, the orientation session. In that session, the mediator will explain the rules and protocols to be followed during the mediation process that's about to unfold. So let's take a look at that opening session by the mediator.
Thank you for joining me this morning. I appreciate your accommodating my schedule because I really thought, after having had conversations with you all previously and having looked at the mediation statements that you were so kind enough to provide, that I really sensed that we could use a little extra time today. And so thank you for coming a little early. I appreciate that. And I want to also commend you for the work that has already been done. We have really already accomplished a great deal simply by the fact that you have shared information that I'm confident you have knowledge of to some degree, and most importantly, you've agreed to come to a place and in a setting that allows us to do something that we couldn't do anywhere else, and that is to have a respectful dialogue. So you signed the mediation agreement, each of you did, and I appreciate that, because what it commits us to here, and I just want to remind you of its principles, is first confidentiality, meaning that what takes place here stays here, as they say, and I can't share anything that I hear from any of you with any other person. What I hear jointly, I cannot share outside of this room. And if we have a private session later, and I'm with either of you or any of you separately, unless you give me permission to share what you've chosen to share with me, I will not share it with another. So confidentiality is really one of the core principles of this entire process, as is my impartiality. Now, I know, and I've explained this to you before, that I know Steve from our work together, and I know Judge Shipley, and it's always hard to call a judge anything other than a judge, but I'll do my best today, if that's okay. But we've had that prior relationship, but we don't have what we would call a conflict of interest. And if you thought that there were such a thing, then it was your right to choose someone else. And I don't know either of you individuals, although I've now gotten to know you just a little bit in our introductions today. So I'll get to know you more today. But that second tier of impartiality is my commitment to you that I don't take sides. I'm here to try to help facilitate a conversation. And the most important thing is that this is a place where your self-determination is preserved. In other words, you decide what's in your best interest. No one will force you. I'm not a judge, I'm not an arbitrator. I can't make a decision for you. You have the right to decide what you wish to do that you believe is in your best interest. And with your able counsel to guide you, I'm confident that you'll make whatever decision you need to make, so that at the end of the day, whatever happens here is because of what you've decided to do, whether you agree or agree to disagree. But that's the other thing that I find so powerful about mediation, because the statistics are pretty amazing. This isn't just me. I'm just saying, generally speaking, a lot of study has been done about mediation. And to get to this point where the people are at the table having agreed to do what you've agreed to do, the likelihood is about 80% of the time you're going to reach an agreement. As difficult as that may seem at the moment, the odds are in the favor of reaching an agreement. And it's the power of this process that makes that happen. And even if they don't choose to agree at the time, more often than not, another 12 to 15% of the time, parties will agree after a mediation, and I consider that a success too. But it's also a success if you decide at the end of the day that agreeing to agree is not in your best interest. That too is your decision to make. So having said all of that, I don't have a lot of rules, but I have but one rule, basically. This is a safe place, which means that people are going to be given the opportunity to be understood. But I'm going to ask you to go beyond that. I'm going to ask you to try real hard to understand as much as you try to be understood. And that's going to require us to do a little bit of careful negotiation on occasion. And trust me, I'm not afraid of emotions. I can understand when emotions occur. They're natural. There's nothing evil about emotion. There's nothing evil about anger. So anger may occur. All I ask is that we follow one guideline. Let's not interrupt. Okay? That's all I'm asking of you. So if you have something to say, if you can agree to not interrupt until the other person has completed what they're going to say, you'll get a chance to say what you're going to say. Is that fair enough? Can we operate on that guideline?
Sure.
We can agree to that.
Sure, we can agree to that.
Are you
We
okay
can
with
too.
that? Okay, good. That's all I ask of you.
Take special note that the mediator emphasized protocols and guidelines that are certainly embodied in Rule 31. Confidentiality, impartiality, self-determination. But notice that he did not do so merely to comply with the technical requirements of the rule. He used those terms and those concepts as tools to create a safe environment, a hopeful environment, and create a conducive situation for these parties to effectively negotiate and achieve success in resolving their dispute. He explained these simple guidelines, but they had a profound effect, as you will see as this mediation unfolds, on what the parties were able to accomplish.
So, with that said, let's begin, because as I understand it, you each have claims against the other. So in essence, you both have arguments or positions about something that the other has done that creates some degree of responsibility. So have you decided who's going to proceed first?
Well, we can go first, if that's okay.
Okay. Steve, let me make sure that I understand who we all are, because I think from the pleadings that we have Betty,
Rowe.
and Steve, of course, I've known for a long time, and we have Jay and Marietta. Is it okay if we use those first names today?
Sure, absolutely.
Actually, JJ.
Oh, is it JJ? Okay.
Okay,
And you can call me Larry, all right?
Okay,
so
great,
if we
great.
can operate on that basis, we can proceed.
okay.
Okay,
very
Steve, I'm
good.
sorry, go ahead.
Very good, thanks. Well, let me make this opening statement then on behalf of my client, then Betty Rowe here. As I've previously indicated to you, JJ here had 2 ice cream stores. And at each one of those ice cream stores, he had 1 full-time employee and 4 part-time employees. And apparently at that particular point, he decided that what he needed was a full-time manager. And so he placed an ad in the paper, and in that ad, he requested that somebody, in fact, he wanted to hire somebody to be a manager of both stores and to handle basically all personnel and operational matters. Well, little did he know that my client responded to his ad. And when I say little did he know, he was surprised by that, because my client and he had worked together previously at a different company about 15 years ago and had a good working relationship. And she had been recently laid off, and as a result then, what I understand is that when she applied, he was delighted, and was delighted to have her and to bring her on board his ice cream business. And so as a result then, they set forth certain terms between the two of them, and he was going to pay her $800 per week. And then at the end of 6 months, he represented to my client at the end of that 6 months that he would review the salary and also consider paying her on a commission basis. There was another term too, and that is that if he opened a 3rd store at that particular point.
That was depending on sales.
Remember, we talked earlier about let's let everybody be heard, and then we'll come back. You'll have your chance to speak.
That third store, thank you. That third store then was, he was going to then share profits from it, and there was going to be consideration of a future partnership. And at that time, he had some sort of employment agreement drafted up that contained a covenant not to compete. And so,
By his sister-in-law.
by his sister-in-law down there. And so that basically what it said is that she would not compete, open a competing ice cream store, and that becomes important. So she's hired as the manager, and she's paid a salary. She's paid on a salary basis, but as I'll tell you in a few moments, her duties drastically change. So what happens after she gets on board? First off, let me just say this, and I want to say it right at the outset. You will not hear today or in the courtroom, if we end up in that courtroom, there will never be a complaint lodged against my client regarding her performance. She did an outstanding job, and there will never be any negative comment about that, either here or if we don't get it settled today, when we appear in a court of law to try to get this matter worked out. So the next thing that occurs is 6 months comes along, and he goes to her and says, no, gosh, I need to put this off 6 months. And then he kind of drops something on her. He says, I'm going to limit you to one store. I want you now to just work one store and be the manager, and I'm going to lay off the full-time employee. So my client at that point is managing in one store, so to speak, for part-timers, and then here's where he effectively reclassifies her. He says to her, she has to work the counter. She's dipping ice cream. She's dipping ice cream 90% of the time. Before she did a little bit of dipping, but now what we've got is she's dipping ice cream 90%. But she's okay. She's doing her job. She understands that because she's waiting for the end of the second 6 months. The end of the second 6 months come, and guess what happens? She goes in and she says, look, I mean, you know, privately she's been keeping a book. She wanted to see how many hours she was working to impress, and you've got your book here today. Good. And so she wanted to keep her books showing how many hours to impress the owner here. And she says, we need to meet. He says, okay, we'll meet at the end of 2 weeks. Well, that doesn't happen. He blows her off again. He, in fact, then delays it, and he meets about 1 month later. Now, up to this particular point, my client's done everything. 1 month later, she walks into the door, and he fires her. And so she is absolutely shocked at this particular point. Not a problem in the world. And after all these delays, he fires her. So the first thing he does is that, the first thing she does is to go out and to open up then, about 3 months later, it's not the first thing, but about 3 months later, she opens up Best Frozen Yogurt. His store's name is Best Ice Cream. And so she opens up a completely different type of operation called Best Frozen Yogurt. And so that's what brings us here is that he filed this lawsuit alleging a breach of a covenant not to compete by my client for opening up a frozen yogurt store. It's non-meritorious. It has no merit. It is meritless. And my client, I've told my client that it is a meritless claim. In addition, when my client consulted with me, it occurred to me that she'd been reclassified from an exempt employee to a non-exempt employee, and she had been working all of these extra hours, and that she was entitled to overtime. And then I came to the legal conclusion that she had at least, and I think a very good prima facie case of an age discrimination claim, because not only was she let go, he retains these teenage 16-year-olds, 17-year-olds to working at the store. And of course, she informed me that during this particular time, a number of these teenagers referred to it, and I'm sorry I need to say these things, the old lady and the graying ghost and that sort of thing. And so what happens is he fires her, he keeps the teenagers. So here's our demand. The fact of the matter is we're going to keep this store open, and I have done a calculation. I've broken it down in my pre-mediation statement for you, $85,000 today, and that number will only grow as this matter goes on. And so we're confident that our legal claims have merit, and the covenant not to compete claim is totally meritless. And so that's our position.
Well, let me see if I've captured it in my own mind, because these can get kind of complicated. What you're saying is that there was a relationship that preceded this employment relationship.
Right.
Went back some time.
Yes.
You knew each other
Yes.
before you worked for him.
That's correct. We worked together.
Okay, and then when you were hired to do the work, you had a contract which had terms in it that you agreed to at the time.
That his sister-in-law
Okay,
drafted, yes.
but you signed it and you agreed to work under those terms. Is that accurate?
Yes.
Okay.
Although it didn't reflect our conversation, but yes.
Okay, and then over some period of time, you had expectations that weren't realized in terms of raises and responsibilities and opportunities, and they didn't occur as you expected them
Yes,
to.
like bait and switch, Larry.
And
Don't-
as you had occasion to try to have conversation with him, when you finally did, I understand that it was at that meeting that you were terminated.
Yes, not after he had me continue to work 60-hour weeks, yes,
And your duties were changed over time.
absolutely.
Okay. And now you're looking for compensation for wage disparities. You should have been paid differently than you were paid under the Fair Labor Standards Act, and you're looking for damages for your age discrimination claim. Do I have it pretty accurately assessed in my mind?
Well, that and the injunction, or whatever efforts to prevent me from, after he's put me out on the street, essentially, from earning a wage, which he knows our family's financial condition.
He
so
has fired her, and now he wants to prevent her from actually earning a living. It
can't
is-
do
It is
that.
outrageous.
Okay, because that's their claim, that the original filing here was for an injunction to prevent you from competing under the terms of the agreement. Is that what really brought this to a head in terms of our judicial activity?
I think that's accurate.
Okay. I just want to be sure I got it in my mind, because now we're going to turn to them and let them have their piece. And you were respected, and even when there was a bit of an interruption, we were able to handle that. So I would ask that you show the same respect for them as we.
That won't be an issue.
Okay, great. Thank you for that. So let me turn it back to you. Marietta, how do you want to address your reasons for being here today?
Well, I appreciate your opening statements about the nature of a mediation, that 80% of it is just getting to the table, which has been my experience. And I would like to just express to Betty and to Steve that, you know, we're here for one purpose, and that purpose is to, first of all, try to put us back to where we are so that don't have her store as an issue, and dealing with these other counterclaims. But you know, my client is here to try to listen to whatever you have to say. He obviously is very upset about this also, but today we are trying to see once whether we can come to a resolution, and that's why we came. Okay. Now, JJ would just like to express a few more things. Now, I don't know if he can keep himself calm enough to try to express this, but this is what we would like to have the story more from JJ than from me.
I can't believe you did this to me. I mean, I taught you everything you knew. I took you out of retirement, gave you a job, and you stole all the concepts that I taught you to open up your own business. You even had the nerve to call it best.
Yeah, JJ, let's just kind of stay on track here and maybe express perhaps the reasons why you felt it was necessary to fire her.
Can you tell us why you felt it necessary to terminate her employment?
The revenues were down, and the expenses had gone up, and we have some big competition in the neighborhood now.
Okay, can we take that apart so that I can get a better understanding of the business problem that you were facing? You had been successful for some period of time, I take it, and were even thinking about expanding, I've noticed.
And the revenues are such that we can't even expand now.
So what happened over the course of time? How did the revenues decline, or what caused that to happen? And why did the profits cease or diminish?
Just a big chain coming into the neighborhood. It just put the hurt on us.
So
slowed us
external
down a little bit.
competition was the reason that you had these business problems. And as I've heard it said, I want to ask you whether you agree with this. It's not because of her performance that she was terminated. It was because of the inability to keep the business operating on the basis of costs and expenses and revenues. Is that a fair statement?
Yes.
And talk to me a little bit about how she was as an employee.
She was good. She was good. She got the job done.
How do you define good? I mean, give me some substance to that.
Well, for her age, she was doing a lot of extra hours, and I'm sorry, I meant, I have a lot of teenagers on the staff, and she was working more than anybody. And she was taking care of the inventory, the ordering, the hiring, the community relations. She was getting it all done. She was a good manager.
Pretty much everything.
So I heard them say that she was well regarded in terms of what she got done and how well she got it done. I'm thinking I'm hearing you say the same thing. Can you give some substance to that? Can you tell me why she was such a good employee, or how that occurred to you that she was a good employee?
Well, I don't think there's ever been a question of whether she was a good employee. I mean, she was a good manager. This is strictly economics.
Okay.
And that's why it was so difficult not only to have the outside competition, but to have basically inside competition when she set up her second store. I think that's also what has distressed you so much. Is that true, JJ?
Yes. She opened up a store, basically the same concept as what I taught her. It just stole all the concept.
And as I understand it, correct me if I'm wrong, that was after she was terminated. Is that correct?
Yes,
So she didn't compete with you before she was terminated.
that's correct.
Okay. Let me ask you, Betty, if I can, talk to me from your perspective about the revenue issue. You heard him talk about the declining revenues and the competition. You had firsthand knowledge of that. Was your assessment the same as his about the issue of revenue and profitability?
Well, he did not treat me like a partner in providing me that information. He just kept me working like a workhorse. When I asked to meet with him and to actually go over these kinds of things and have this conversation, he put me off. He asked me to continue working harder. So I did that, and ultimately he just got around having that conversation with me, kept me in the dark around that reason. I put a ton of sweat equity into this business with a promise that we were going to be partners, and he didn't share that information to me.
That had to be disturbing
Absolutely.
and disappointing.
I wouldn't, beyond disappointing. This is my livelihood. You know, he keeps referencing my age. At my age, to be working like a 16-year-old, 18-year-old, and to do that for 60 hours a week with a carrot being dangled out in front of me. I mean, put yourself in my shoes.
Well, as I look around, I think none of us are spring chickens, as they say. I think we can all probably claim to have a little bit of water under the bridge, so we're all pretty much in
It's
the
just
same
not,
boat.
it's
Speak
not
for
funny.
yourself.
I mean, I understand that you're making a joke, but he left me in a situation where I was being, you know, treated in a harassing manner by the young people that worked there, and he did nothing about it.
Did you share that with him?
He had to have known about it.
So you didn't actually tell him of those
When?
experiences?
When? At the meetings that he cancels?
Okay, well, let's go into that a little bit. Did you ever have conversation with him during the course of these long hours that you worked?
You know, very little, very little. And the message was, I just need you to do this. Now take this. And so you heard my list of duties that were listed in that ad. And it went from a supervising managerial position to me wearing a hairnet. Okay? I mean, I had a very successful career in the medical device industry, sales. I have a huge skill set, and now I'm giving people samples.
You feel demeaned?
It is demeaning. And here's the thing. I know if you're a business owner, you have to wear all the hats. And I was willing to do that. But he took advantage of the situation and left me running everything and was MIA, Larry.
Well,
MIA.
Give me an idea of how frequently you would at least have a telephone conversation with him during any week.
Oh, I don't know that it was every week.
Okay. Well, you had responsibilities for a store. You had responsibilities for the collection and the reporting of the revenues in that store, as I understand you. Is that correct?
I would just go to him with problems. I mean, if there were problems, if we needed to increase orders or decrease orders, if something needed to be maintained, it was very little feedback on his end.
But you had the freedom to share with him the problems that you were encountering.
That the store was encountering. You know, my generation, we do not complain. We keep our heads down. We work hard, which is what he's already said, that I was an excellent worker, and I was. I mean, without me, I mean, there's no telling where the store would be.
And clearly, I don't think there's any dispute that I've heard at this table that you worked hard, that you were highly regarded for the work that you did in terms of its efficiency and effectiveness. So that's not even in question, if I'm hearing it all correctly.
It's in question to me, because you don't treat highly regarded people the way that I was treated.
That's a really good observation. So let's examine, if we can, from your knowledge of the way in which the store was working, was there a declining revenue that you experienced in the store over the course of time?
You know, foot traffic did go down, and I started noticing that we were going down on orders. But you know, businesses go through seasons, so not having the big picture.
I understand, and without all the data and details, it's impossible.
Exactly.
But let me ask you this, because I've heard reference to this competing store. Do you think it had any impact upon the foot traffic and the revenues at your store?
No. You mean the national business?
Yes.
Maybe, and ideally we would have had a conversation about it before I'm being given my walking papers.
So what I hear is you feel disrespected for not having been able to have that dialogue as a colleague with your boss.
At a minimum.
And I heard that there was friendship. How did that friendship start between you and JJ?
Well, you know, we worked together in sales at the medical device company, and I knew him through that company. He was a good salesperson. I was as well. But there was downsizing at that company, and over time, you know, we began a relationship. Our spouses, we would have dinner, and became what I thought were friends. It was a friendship. And when he heard that I would be on the job market, or I was interested, I was excited to be working for someone that I had some history with. I knew his spouse, I thought I knew his values, but it turns out I really didn't. You know, I think that makes it even more painful, especially when I get calls from your wife. That's ridiculous. I mean,
can you talk to me about that? What calls do you get from
his wife? Calls me.
Go ahead. Tell him.
His wife called me and really just in a very demeaning manner let me have it for trying to keep the lights on at my house. I opened this store. It's, you know, a completely different business. It's not ice cream. I pick a location that has its own market, very isolated, and she won't even listen to how her husband put me in the situation where I had to go out and create my own opportunity. And I refuse to grace her comments and meet her insults, but you can see that they're not the kind of people that they're portraying themselves to be. Very nasty.
Let me ask JJ if I can.
I understand you're upset, Betty.
You see what I'm talking about?
Well, let's talk
We
about...
don't need to be pugilistic here.
I think that's a great idea. So let me ask you a question about that. You decided before she worked for you that she would be someone that you felt would be worth having as an employee, and as I understand it, potentially something more in terms of the company and its growth. Is that a fair assessment from what I've heard so far?
Yes.
What were the reasons that before you hired her, you thought that would be wise?
Well, I'd known her. We'd worked together for a while.
So what were the characteristics or attributes that you valued?
She was a go-getter. She could get the job done. I knew that.
Anything else?
She had a good rapport with the clientele, the customers.
Did any of those things ever decline over the time of her work?
No.
Okay. Now, Betty, I need to ask you a similar question. You had a choice before you went to work for JJ to either take that job or not. Why did you take the job?
I took the job because I think the idea of stepping into a business opportunity with someone that I thought I knew and trusted was appealing. You know, at my age, I didn't want to keep traveling and doing sales for another company. I like the idea of working for myself and building something, and I absolutely was willing to work for that. I wasn't expecting to be handed anything, and I worked very, very hard for that, and I knew it would be hard work. It's just not what we discussed.
Okay, well, I think that's very helpful, and I know it feels like we may not have made a great deal of progress. I want to assure you that I think we have. But I told you on the front end that we might have a private session, and I think it might be beneficial for me to talk with the two of you. And so we're going to ask you to be in your mediation space that we've created for you. And while you're there, I'd like for you to think about any of the details that can better help me understand the business failures that you've discussed.
Okay.
What were the causes of those? How can you objectify that for me? If you could help me understand when we
Okay.
get back together, okay?
We'll do that.
So we'll take a break, and then I'll come back to you, and then we'll have a private caucus as well, okay?
Okay.
All right.
It is important to observe that the mediator views and attempts to utilize the joint session as an important and critical part of the process. Rather than rush to caucus or private session, as mediators sometimes often do, he uses the joint session to not only set an agenda and begin discussing the issues that will be at play, but to start a dialogue between the parties themselves, and he moves to private session between the parties only when the process naturally unfolds and calls for that step to be taken. Now let's go take a look at the private session between the mediator and Ms. Rowe and her attorney. Take particular note of the fact that although Ms. Rowe's attorney still exhibits his adversarial litigation style of advocacy, the mediator doesn't flee from that or ignore it. He finds a way to use that attorney's style and still facilitate a dialogue that proves very effective.
Like I told you before when we were all together, I want to remind you of one thing, that what you choose to tell me here is confidential. I will say nothing to them that you don't tell me that I can. So understand that that's a ground rule here,
We
okay?
understand that, okay.
But I am interested, however, in trying to pull apart some of the behaviors that have obviously deeply hurt you. And I'm not talking about your behaviors, because clearly, from everything that I've heard, you've done nothing wrong. Am I
Thank you.
right?
Thank you.
I mean, I haven't heard that you've done a thing
The
wrong.
mediator sees it, at
That's
least.
right.
But the question I have is there reason to believe his reasons? In other words, were there economic issues that the store was facing that became at least somewhat obvious to you as a result of the new competition of the other national chain opening nearby? And as you said, the loss of foot traffic and the loss of orders. Was that a reality?
You know, maybe, maybe. Do I think that it was the only reason? Absolutely not. And do not let them pull the wool over your eyes
Speak to
around
me
that
about
piece.
that.
Well, you know, here's the thing. You can't open a business and then just never be there. You have to, part of the reason that he brought me in and the whole workings of this business is that we have to be out there marketing. My skill set is not scooping ice cream. My skill set is sales, building relationships. He's already said that I was acknowledged for being a superstar in that area. But he has to as well. And if you are not in your business, it's going to fail.
Do you have any reasons to know why he wasn't in the business?
Larry, I don't know what he does in his personal life, and certainly I'm not as close to him and his wife as I thought I was. You'll have to ask him that. But he was leaving all the time with no notice, and it's like he was never really there when he was there. Very distracted. It was unnerving, but I mean, what is a person there's only so much I can do.
And you felt like you were not heard, you were not appreciated, and that left you high and dry in terms of the reasons for this unexpected event.
Notice how he allowed those emotions to be expressed, but by affect labeling, allowed them to be productive rather than counterproductive to the process. This is a skill that's often seen in a style of listening that's often used in the transformative style of mediation, which again illustrates another point of our exercise today. Here's a skillful mediator who can successfully employ several different styles of mediation in a single process.
You know, their apologies or whatever that they're saying that they value me, it's a day late and a dollar short, Larry. A day late and a dollar short.
Okay, that's good conversation to have. I heard the number $85,000. Is this just about dollars and cents, or are there other things at play here that you really need to get in order to get this resolved?
Larry, I'm on a fixed income. He knew that when he brought me in. The kind of work that he has gotten from me, I could have built 2 other companies with the amount of labor that he's gotten. And, you know, put us in a very precarious position. So absolutely, finances is a huge part of it. And it's taken away my vision for doing this in partnership with someone else.
That's important to you.
It is. And now I'm starting over in an even worse position than I was.
Let me interrupt you. Our position is that obviously there's 2 parts. When she's going to keep the store open, that's extraordinarily important because she hopes at one particular point that's going to provide a revenue stream.
Let me interrupt you right there. How's that going? I was going to get to that. Is the
It's
store
going well. I did some homework and I studied the area. It's a great location on Franklin Road. It's near an apartment complex, so we've got kind of a captive audience of young couples. But again, that's me using my expertise, not scooping ice cream, finding good locations.
So you have optimism that if the store can continue, you have a means of recouping
if
some
we're
level.
not wasting time doing this,
So
and I'm not getting threatening calls and threatening letters, and it's nowhere near this national competitor.
So that would not even be a significant factor in the success of the new store.
Exactly.
And let me ask you, it sounds like you'd rather this be over than to be enmeshed in this conflict for any length of time. You want it to be done.
Absolutely.
Can you give a value statement as to what it would be worth to you? I'm not talking dollars. What would it be worth to you if you could just be done with this today?
You know, it's pretty important at this point. I really do not have the time to, I'm the breadwinner at this point. We're on a fixed income. This is no laughing matter. Right. And you said earlier, we're no spring chickens. I can't keep starting over, Larry.
Yeah, and you know, in terms of the reality of all of this, and although I promise you, I think we got legal claims, but the reality is that he's sitting there with a free lawyer in all likelihood, and I just need to tell you, you know, there will be legal costs here that can come up, and so that's why we view this keeping this door open as very important. But one of the aspects of this is in addition to all the other things, is the legal costs are going to be fairly significant if this goes to court.
But if
They don't need to know that,
Okay.
though.
That's right. They don't need to know
They
that.
don't need to know
Right.
that. And again, you know, this is the same lawyer that drafted the fuzzy agreement that was really fuzzy for him in his favor.
Yeah,
And so,
let me ask the mediator that. Larry, don't you think that, I mean, this covenant not to compete is not enforceable?
You've
Wouldn't you
read
agree
this,
with me?
right?
You've read it.
Well-
It can't be, you know, frozen yogurt's not ice cream and it's unreasonable in other ways. Wouldn't you agree with us?
Well, first of all, it's not my position, it's not my role as a mediator to give legal advice. Matter of fact, I'm
but you're a
prohib-
lawyer.
I am, and I have experience, but let me tell you something.
You've got
I-
experience in this. Just
I
tell
don't
us what
have
your
near
opinion
as
is.
much experience as Steve. So let me put it back to you, Steve. How many times have you seen covenants not to compete not enforced?
Well, I've seen them not enforced a number of times, yeah.
And
Well,
so-
there's that other case you were telling me about in that
That's
other
right.
state where this was it's exact same thing.
Well, are things ever exactly the same? I mean, there are
Well,
always variables, isn't that
there-
right,
there-
Steve?
there's always
Larry,
some
who
differences.
are you arguing? I mean, are you? You said earlier that you were going to be neutral, and now I'm feeling like you're trying to poke holes in our case.
I'm just trying to help us face reality, and you've got an excellent lawyer. And as a matter of fact, I would choose Steve as my lawyer if I were in your situation.
Let me just say this.
Except
is
he's
that-
very expensive.
I don't
That's
doubt
right.
that. And he
And
deserves
we
it.
understand that's one of the reasons why we'd like to get it resolved, is that even though we're confident in our legal position, obviously, you know, we've had that conversation where there's no guarantees.
Mm-hmm.
You know, we understand, and so that's why we're here, is that, you know, someone could take this language and consider that, in fact, there is that possibility. I think it remote, but there's a possibility that store could be closed down.
Okay, so there's a risk there. That's all I'm wanting us to do. is
And
just
I want to make
under-
sure we all understand there is a risk, and
I
we've talked about
understand
that.
Okay.
I understand that.
And you may not be able to answer this question, but you've got far more experience on this than I do. If you were to take this kind of language and seek to have it invalidated 10 times, how many times do you think it would be invalidated?
Oh, you know, there's never any such thing as 100%, but 8, 9 times it'll be.
Okay, so there's at least a 10 to 20% risk, even from your assessment and your experience.
Yeah, there's some risk.
Okay,
I mean,
that's all-
I can't tell you what the judge is going to do.
And so therefore, I'd just like for us to hold on to that for a minute, hold the tension of that risk, in contrast to what you said earlier about your desire to be done with this today. That's all I'm asking.
Notice also how adeptly the mediator avoids a trap that mediators are often placed in. He adeptly refrains from giving legal advice. Legal advice is prohibited by Rule 31, and the mediator deflects it very skillfully by the use of fair and balanced questions being put back to the party and her counsel. And in essence, he turns this back to counsel to answer the questions that the lawyer has attempted to make the mediator answer.
I would like to explore what else you need to make this go away today.
Well, in addition to being able to go out and earn my own
In
living,
addition to all of those things.
and him leaving me alone.
In addition to all
he,
of those things.
he and his wife need to apologize. They need to apologize for the way that I have been treated, and I'll take that apology in writing and with a check.
And if you were to get an apology that was acceptable to you, and all of those other things that you asked for, considering this risk, would you be willing to reduce the amount of money in order to cover the risk? In other words, cover your bet.
You know, Larry, I'm here. I knew I wasn't going to leave here today getting necessarily what I asked for, but it's got to at least convey to me that he gets the situation that he put me in.
I can't ask anything more of you than that. So let me know what I can share with them as a result of this conversation. You didn't want me to share your concern about his fees. I won't share that.
Thank you.
Anything else that you're giving me permission to share or not wanting me to share?
Yeah, there's only one other thing, and that is that my client is not a lawyer, and so when she said that that's probably not the only reason why. There was some reference to that. I don't want you to be conveying then some comments about that there may be some other reasons why she was terminated. And so
Okay.
there was a comment by my client that, you know, maybe that wasn't the only reason, if I understood her correctly.
Okay.
And so then, of course, the comment about the cost here. We understand the costs are going to be much greater for her than they probably are for, you know, a client that's got a sister-in-law for a lawyer.
I see. Okay. Well, I'm going to ask you to do something similar to what I asked them to do. I'd like for you to begin to think about what the value to you would be. You know, you've asked for $85,000. If we can walk away today with all of that behind you, and you continue to operate your store with the opportunities that you say are very, very real, what would that be worth to you? I don't want you to answer the question now. I just want you to talk about that together and see if we can put some numbers on the value of that.
Can I say one more thing? If I'm going to do that, he can't be trying to hurt my business, disparaging me, that sort of thing. So it's really, let me go prosper, let me work hard. And if he wants to let his business fail, he can do that.
Yeah, and we got a wife to worry about. His wife also was making negative comments.
Yes.
So we want to avoid this disparagement.
Sure.
And then when we can work with them, we won't disparage them.
So a mutual
Absolutely. I've never done
non-disparage.
that.
Okay.
Sure.
That can be a part.
Sure.
All of these things are part of a way in which we could perhaps fashion a go-forward relationship. So non-disparagement, a resolution today, allowing you to continue operating your business.
And Larry, the name of the business is not that big a deal to me.
Okay.
I mean, really. I mean, we've talked about that, but, you know, no one recognizes his brand anyway. So if changing the name is not a drop-dead issue for me.
Well, that's really good to know, because even if we have an ugly...
You don't need to convey that to
Okay.
him.
I was getting
but
ready to say, we want
Okay.
that part of the negotiations
In
here.
fact, I'd love for that to be your idea at some point,
Okay.
rather than us float it.
We can hold on to that for a while, but
Okay.
I just would like to remind you, even if we have an ugly baby, it's our baby, right? And it's always going to be a beautiful baby to us. So
I hear that. I
Okay.
hear that. He's proud of it. I'm not going to disparage it.
Good.
So
that's a
Yeah,
great way to go
that's
into
not the way
this.
we've played it. Yeah,
Good,
my
very good.
clients, yeah,
Okay,
okay.
what I'm going to do is go back with them now, and I would like for you to do that work together
Okay.
that I mentioned, and we'll be back together, okay?
Okay.
thanks, Larry.
Now, as we move into private session, JJ, Mr. Founder, and his lawyer do in their private session while the mediator is speaking with Ms. Rowe and her attorney. Note particularly how JJ's attorney continues her collaborative model and coaches him in that concept, how it differs from court and what they will try to accomplish in the court litigation setting versus what they're trying to accomplish today, and how effectively she brings him along to accept this collaborative model and embrace it.
What's the deal? I thought we were here to win. I want to win. You got to get in there. And
Well, that is.
can't you quote some passages out of a law book or something like that?
Well, I want to tell you, JJ, that we're at a totally different place than this win-lose kind of thing. Now, if we do not get anywhere today, we will be going in like gangbusters into court. I mean, there'd be a lot of stuff that have to be done, and we would be ready like we're going for battle. Okay, but today is different. Okay, now tell me how this lawsuit has affected your daily life.
Well, it's wearing me out. I mean, $85,000, wouldn't that scare
I
you?
know. I think that's very, very scary, and you know, Steve has just put that in to just, you know, make you scared.
Oh,
I mean, that's what lawyers do. You know, they do these outrageous sums so that you settle for something much less. But today is an opportunity, and that's why I want to make sure you understand this. This is different than court. This is an opportunity, a free opportunity, to see if there is a resolution here. Because how good would it feel if you left this office today and did not have the sort of mantle of conflict on you? Would that feel good to you?
Yes.
Okay. So what we've done is we've left our swords at the door. Okay. I don't think they have, but we have, because we know that high emotions really just cloud your judgment. Okay. So we want to have good judgment today, because this can be resolved. We have some ideas on this that we will share with the mediator when he meets with us.
Okay. All right.
So if you can just kind of keep yourself in check and listen, I think we'll be okay.
Okay. All right.
Thank you for the time that you allowed me to have, and I think we've made some progress. I really do, and I'm not just saying that to give you false hope, because I think there's some recognition that's settling in that this is not going to be a fun tour if we take this much further than today. So as a result...
Well, I mean, you were in there a long time, so I
Yeah, what were
assume you
y'all
made a
doing?
lot of progress.
I'm going to have the same kind of conversation with you, I promise you, and so we'll take as long as it
Okay.
takes. We're not limited by time. Matter of
Okay.
fact, if we don't finish today, we'll just start another day. So I'm
Okay.
not worried
Well,
about the
thank you.
clock, and I want to give you all the time you need, just so you know. So the question I asked you to talk to me about, to be prepared to share with me, has to do with what were the business issues that were really causing the decline in revenue and therefore the loss of profits? What can you share with me about that?
Well, I just want you to know before we even get there that, you know, what we're here today is to have her close her store and don't want to deal with his lawsuit anymore. I mean, it's, you know, we're sorry that the decline that he's going to tell you about happened, but I just want to be sure that you understand why we're here today.
And I understand from your original complaint that you want to restrain her from competing with you, right?
That would be correct.
You've asked for an injunction to prevent her from operating her business. So I know that's what you've asked for in the complaint that's presently in court. But there are reasons behind the need for that. And that's what will help me understand how we can begin to put these two very different positions together. So can you help me with what were the reasons in your estimation that business declined to the point that you had to get rid of what you said is a very valuable employee?
I don't know. I'm really losing it. I don't want to go to court. I've the stress. I can't handle the lawsuit. Thinking about that $85,000. My revenues are down. My expenses are up. The big chains are coming in. There are yogurt stores going up all over the place. I just want it over. B and Bob were friends of ours. We did a lot of things together. I've got a sick mom in Atlanta, and she's going to have to be put in assisted living, and I know that's going to be a big expense, a lot of time for me to take care of. And I know that I really botched it, and I terminated the way I cut her loose, and it's just bothered me ever since I did it. I mean, I just don't know what to do.
Well, anybody
I
would
understand. I really botched it.
Well, yeah, that takes a really big person to say something like that, and I want to treasure that as a really important message that you have just acknowledged, because it may be that we can use that to your advantage to get rid of this lawsuit. And the reason I say that, she doesn't understand why either. She has no way of comprehending.
I don't see how she could not know.
Well, that's a really good question, and I've tried to explore that, and part of the reason that we were there so long was to find out what she did know. Now, you can tell me if it's different, but what she said was you were never there. And you've just given me reasons to believe that's reasonable, that you had many things to take care of, including a very sick mother, and that you couldn't be on the site all the time. Is that a fair assumption?
That's correct.
And so your inability to be there and for her to have exchange with you, did that not have some negative effect on the ability to get the job done from your perspective? Okay.
Yes.
So is there any way that the knowledge that you, quote, botched it, could be communicated to her in a way that can help her get over the hurt of what she felt was not only a good friendship, but a potential partnership. And we heard it. She wanted to go into business with you. And I honestly, I think she might still. I don't know that.
So is this the hurt that she expresses is coming out in putting up a competing store and saying tacky things about him and blaming him?
Great questions. I think we can work on the, quote, disparagement issue. I know nobody wants to disparage the other, so one of the things that we could conceivably put into an agreement is to cut all the negative talk out. You may never go into business with each other, but you might have that desire. I don't know. I'm just exploring the business reasons behind this very difficult situation you were in and how this might give us an opportunity to address those. So any ideas that you have would be very helpful.
Well, you know, he's told her he's sorry. So I don't know what more you want on that sphere.
Well, there's some components or elements of sorry that I think really we need to focus on. And the first one you've already done. The first thing you have to know in order to say I'm sorry is you believe it. And I just heard you say, I believe it. I believe I botched it. Now, you don't have to use those words, but you first of all have to believe that a sorry is an appropriate thing, and I think you're there.
You can do that?
I am.
Okay.
I might not be able to, but...
And you don't have to,
I
because...
can't believe I did it.
Okay, see, that's a pathway for us. Because if you can honestly own that and express that to her in a believable and authentic way, I think we could break through a lot of obstacles here, because more than anything else, this is just my opinion, that's what's driving this complaint.
Okay.
Is her sense that her friendship with you and her possible business partnership with you was ended for no logical reason that she can't understand. If you could own that and then be specific in terms of what it was that you are sorry for, and then offer in some way, now I don't know what this means, maybe you can have a way, and this is where the two come together. You know, what they say in recovery is make amends. So what would an amend look like? You may have an idea, but if you can couple those things, you might have her attention, and we might be able to break through this. So help me be creative here. What amends might we be able to offer?
We could join forces.
What does that look like?
You mean like really work with her?
Ice cream
Deliberately?
and yogurt.
Pardon?
Ice cream and yogurt.
Ice cream and yogurt. Well, you say there are a lot of yogurt stores
And
in
you don't
your
have
area.
any business in yogurt presently, is that correct?
That's correct.
You like yogurt.
Which she does.
I know, and from what I hear, she's really got a good location, and she's done the market research. She's optimistic that if that can continue, that's going to be a revenue generator. I wish I could explain to you how badly she wanted to go into business with you. And you know, if there's a way we can get over this hurt, I'm not guaranteeing, I have no idea. That's maybe
Well,
not
I mean,
outside
we're-
of the norm.
If you can manage that, I mean, we're up for that if we think that might be helpful.
Okay, let's start this way. What I think will happen best is for us to come back together so that you can deliver an authentic apology, okay? And let's practice that if we can. So the first thing I've mentioned is that you've got to believe it, and I'm confident that you do. If you could say to her what you said to me, I think that would be huge. And then be specific. How did you botch it? What should you have done differently? And if you could do it over again, what would you do differently, right? And then let's open the door. Make an amend. Suggest whatever you feel might work to bridge this gap. And if that means joining forces, then we can begin to explore that. Can you do that?
We might also ask her if there are other things that she's upset about.
Yeah, we need to know.
Okay. Let's start with the I botched it, and let's
Find out what else is
Right.
Okay.
And then let's see, what else there is that you may have, from her perspective, have botched. Are you ready to hear that from her?
It's going to be hard.
It will be hard, there's no question about it. I want to minimize how hard it will be.
But I think JJ's up for it.
And I've watched the way that you have worked to make this happen, so I think the team is right, and I think we can have a very good conversation. Are you up for it?
I think so.
Okay, we're going to come back into joint session. I'm going to ask them first if we can do that, and then we'll come back together, okay?
Okay.
All right.
It is very important to note how the mediator did reality testing with each party, not by giving an evaluation, but by the careful use of fair and balanced questions.
Thank you both for the time that you allowed me to spend with each other. I think that we have something that can at least give us a foundation for further conversation. And JJ has asked for the opportunity to say something to you, Betty. So I'm just going to let him speak his piece.
Betty, I'm truly sorry from the bottom of my heart. I realized I really botched the way I let you go. I know we were really good friends. Our spouses were friends. We did a lot of things together. And I can't believe the way I handled your termination. It shouldn't have happened that way. And I just want you to know from the bottom of my heart, I'm really, truly sorry about it.
Are there any reasons that you can share with Betty as to why you feel like you may have botched it?
There's been a lot of stress going on in my life. Not only the competition for the big chains and the yogurt stores coming up everywhere, the revenues being down, but my mom in Atlanta is very sick and suffering from dementia, and I'm going to have to put her in assisted living. It's going to be a very difficult task for me, and that's why I've been gone a lot. And that's why I haven't been up to date on what's going on at the store or what you've been doing. And I just want you to know I apologize. And I know it's not an excuse, but I just want you to understand that I really did botch the termination.
Betty, when we all started, I asked for us to try to understand as much as be understood. And so I want to turn it to you. What else do you need to know from JJ to be able to understand, from his perspective and his words, how it botched? What else do you need to know?
This is really coming out of left field for me. I don't understand why you didn't, why you felt like you couldn't tell me what was going on. I think, I just don't know what to say. It's, what did I do that led you to think that I couldn't handle that information? Why you kept me in the dark? I appreciate you saying that you botched it. I agree, you botched it, and I'm really glad to hear you say that. And I didn't know what was going on with your mom, and I hate to hear that. It's just, you have got to understand the situation that you put me and my family in, and now you want to take away the only options that I have other than, going and working for someone else. And I hear what you're saying, but I do not feel that you appreciate the financial situation that you put me in after how much of my time and energy and sweat equity that you got from me. And maybe that's because you're tired and you're stressed. And I really hate that it took me spending what little savings I had to hire an attorney to have this conversation with you. But you put that cost on me as well, So I hear what you're saying, and I still don't really understand, based on your comments and your attorney's comments, that you're going to now come in and start throwing weight around and saying what I can do to earn a living when you've created this situation. I'm not hearing anything around that.
Well, I would like to sort of focus on that, because what I'm hearing you say is, so what, right?
Right. I'm not heartless, Larry. I appreciate his situation. And, my heart does go out to him. I can only imagine how stressful that was been. And what am I supposed to do?
Great. Well, I think that's the right question to ask, because I think JJ has a suggestion. So are you open to a suggestion?
Yes, but maybe I'm talking too much, and you should take over, because I feel that we have some real legal claims here, and I don't want it to get lost in the shuffle.
Yeah, I think where we're at is this. I think it's time now that we move toward, and I'll say that certainly that you shed some light on some things that certainly that my client certainly didn't understand, because she never shared those with me. Though those were new things. But I think it's time to find out, is how can we resolve this? I think we ought to move toward what is a possible resolution here, and I think that's why we're here. And we do have good legal claims, but we're also here to resolve this matter. So we need to talk about how are we going to resolve this.
Are you interested in hearing JJ's ideas?
I think that's where it needs to come from.
Okay. JJ, what idea are you willing to share?
We could be a team. We could work together. We could fight the big chain with our expertise and knowledge and what we know already. Yours in the yogurt, mine in the ice cream. Our friends in the community.
Which would that mean that she wouldn't have to close her store?
That's correct.
So what I'm hearing him say...
Because her location is really a good location.
So what I'm hearing put on the table is an opportunity to continue operating your business. And I also heard you say that doing it alone was not to your liking. So is there a way that we can now talk about, as you said before, there are legal claims that we have to deal with, no question about it. But let's talk about what the go forward might look like if there was a way to join forces with a local enterprise to take on this national chain that's sort of interrupted both of your well-being.
Now, Larry, before we even, when we came here today, this was not even in our sphere at all. I mean, we came here to shut down the store. Okay. But, so before we really get into this, if they even have interest in this, we would have to know that this lawsuit was basically gone. Now, we may be able to add some money to this, but we're happy to talk about that, but we don't want this $85,000 lawsuit continuing on.
Okay, that's very fair, and we can do this in either direction. Maybe the first direction is to deal with the dollars attached to the claim. Now that there's a possibility that shutting down your store isn't an option, and the benefit of joining forces with another established business might also give you added ramp to improve your revenue. So taking that into account, do you want to now address the dollars and cents of the claim? Because I hear them saying it can't be $85,000.
Well, let me.
We'd have to talk together.
Yeah, we'd have to
Okay.
talk, and I think that maybe the way that, and we in some of our previous discussions is that I understand we're getting the cart and the horse here and all of that, but what would this partnership look like? I mean, if we're talking about 95%, 5%, I don't think my client's interested in that.
Okay.
I think that to the extent that we can see the details or start putting a little bit of flesh on that, some meat on those bones, then maybe then I think that we've talked about how that can go away. But I think that, just simply to say, okay, well, partnership and all this other goes away, I think there needs to be some discussion about what is, I think borrow one of your terms, Larry, what does that look like?
Well, I think that's a great observation, and it may be
Well, we're in the same boat. I mean, we hadn't even considered that
This-
before.
it's a
So we
brand new
may
thought.
need some time.
Absolutely. And that's what I was
And,
going to suggest. Maybe the best way to proceed today, if I can get understanding on a couple of key points, that you're willing to, as we say, compromise your monetary claim if you can work out the details of an ongoing partnership relationship, which include not forcing her to close down her store, but joining your forces together in some to-be-determined relationship that perhaps your lawyers can help you define.
Well, if I can add to that then, if we're going to do that, obviously we're going to have some time to do that. Number one is that we don't want any more legal proceedings to try to shut down the store. She's going to continue to operate the store. That's one thing. Do we have an agreement on that?
Well, great, let's stop
As
right
long
there.
as we have a time limit. I mean, if we can't work out the details,
What would be a
it's
reasonable
it's
period
sort
of
of
time?
like a,
Yeah.
détente.
I agree. Okay,
Yeah.
that's a good word, detente.
Would 60 days be too much or too little? To just hold the proceedings in abeyance, to give you the time to work out the nature of an ongoing relationship?
Well, will the judge give us additional time, do you think?
If you
we
ask for it.
Ask jointly for.
Yeah, we can
I think
ask for a joint.
She gave us 30 days, so
Sure.
we may need to say, we think we can maybe work this out if you give us 60
okay.
days.
I don't know a single judge that would refuse that. So, I mean, what the judges that I know are looking for is for the parties to resolve their
Right,
problems.
she kind of snarled at us when we went to court last time.
And the second thing is, during that period of time, and I think it's an understanding, we're not going to have any negative comments, any disparaging comments and that sort of thing. We want to have an explicit understanding of that.
Well, that won't lead to a good business relationship. We know that, right?
Okay, I think that's obvious.
And that's really you having a conversation with your wife. I mean, my husband has stayed out of it, and maybe if you say to her some of the things that you said
Well,
to
she
me
was
today,
just being loyal to her husband, like
she was
should
she was
be.
misinformed.
She was.
Okay.
You're right, she was.
Okay.
And we're really sorry that you had to face that. I know that's really
And can I ask you?
tacky.
Can I ask you if there are any other issues that you're upset about that I need to know?
Well, if we do this going forward, I'm glad that we both have attorneys that will help us really nail down how we're going to do this, because if we are going to go into business together, we have to have some agreements around regular communication and how we're going to make decisions and sharing information, because I don't want to end back up in this room as much as I like you, Larry. We have to really nail some things down, because if I'm going to put in sweat equity, I have to know what we're both committing to and what that looks like. So I am willing to.
I think JJ has learned his lesson on that. Communication is, no matter how bad the news is.
Well, what if we did
Important.
this? What if we said from today by 60 days then, that the lawyers will go about setting up a series of meetings? And then, Larry, would you be available then if we needed your?
I'll be available whenever you need me to be.
Okay, and
But I
then-
don't have to be there if you don't
I
need me to be.
understand, but I just wanted to, that we may in fact be calling upon you. And then at the end of the 60 days, we'll report back to you. Does that work for you?
What I would envision here is just a short memorandum of agreement, and either of the attorneys can write it out.
Okay.
It's not a
Okay.
detailed agreement, it's just, these are the key points
The
today.
term agreement, is that
Yeah,
what?
basically, just a couple of bullet points. The first is, we're going to hold legal proceedings in abeyance. We're going to hold them.
I see
Static.
Marietta's writing. I'm going to defer to her.
For-
Can I ask Jay a question,
Certainly.
please? I know that you said that the Poplar store was not doing well. My store on Franklin Road is doing well, and I don't know the situation with the lease on the Poplar store, but during this 60 days, I've trained those employees. Would you be open to exploring shutting down that store and maybe moving some of the inventory over to the new store?
That's a good idea.
And we can talk about that, but then those folks don't lose their jobs, and I don't have to go out and train a bunch of new employees.
That's
so.
a good idea.
Yeah, we need to know when your lease is up. You're going to want, you know, when that's going to happen. There's some details
These are
here.
really good.
It's next year.
Okay,
Yeah.
these are really good details for you to now get into, okay?
Yeah.
So for today, let's just do this. We're going to hold the legal proceedings in abeyance for 60
Okay.
days. The lawyers and both JJ and Betty are going to get together and start working those details out. There are lots of details, including the kind of operating agreements you want to work with, but your lawyers will be able to help you with that. So that's the next step. The third is that we're not going to say bad things about each other.
No reason to at this point.
Okay.
I think we realize that
And
didn't
no
help.
extra phone calls from
And
other
I feel
families.
better about that. I feel a lot better about that
And
now that
then-
you've shared what's going on.
I'm sorry, I interrupted. And then the fourth thing would be, if you need me, I'm available to help along the way. But at the end of 60 days, you'll report back if you haven't reported back until then, so that I
Okay.
can know if you need me to do anything else prior to then or at that time. Is that a fair
I
outcome?
think that's fair. I think,
Yeah.
Steve, you and I can maybe get on a joint call to the judge and
We can do that tomorrow.
ask her, tell her what we've come up with, and will she give us additional
Yeah,
time?
that works.
Okay.
That works.
Well, I can't tell you how much enthusiasm I have, because as you've said, and I think as you're probably prepared to admit, you never would have guessed this when we started
Nope.
at 8:30
Did
this
not at
morning.
all.
It's
You were
taken,
right.
it's taken a
Of
long
course
time.
I'm right.
But you all work so hard at it, and I really deeply appreciate the effort that you've given, and I'm going to commit to work with you to this point forward to help this make it a better outcome. So, thanks to
Okay.
all. Marietta,
Great.
thank you.
Thank you
JJ,
very
thank you.
much.
Steve, appreciate it.
Thank you
Betty,
very
thank
much.
you very much.
Thank you, Larry.
As we wrap up our session today, we certainly want to thank you for being here with us. I'm sure that you will agree we've learned many things from this mock mediation that we've observed. I think, however, it'd be appropriate to list a few of the things which stand out. First, we noticed that this skillful mediator, like all skillful mediators, can use differing mediation styles in the same mediation process. Number two, we noticed that we had two lawyers exhibiting different styles of advocacy. One, as we mentioned, an adversarial litigation positional style of advocacy, and another, a mediation style of advocacy. The mediator did not run and hide from those different styles. In fact, he embraced them and was able to use each lawyer's style to still facilitate effective negotiations and discussions between the parties. Number three, although no final agreement was reached between these parties today, they created a plan. They created a plan that will most likely lead to a successful resolution of this dispute, a resolution that will provide benefits to these parties that no court of law could ever give them. And lastly, we noticed that the mediator wisely had these parties write down and create a memorandum of understanding of the points of their plan that they had agreed to today. He had the lawyers draft that memorandum of understanding, which is also a very wise step for a mediator to take. Again, thank you so much for being with us today. We look forward to seeing you in our next installment.